Representative Graham for your amendment.
Okay. This amendment pertains to employees, and it states that the Board of Regents for the Kentucky Community and Technical College System shall establish a personnel dispute resolution system that results in the final stage in an independent third-party appeal for all employees of the Kentucky Community and Technical College System. It simply means that if there's a grievance, that the employee into the grievance procedure will ultimately, if need be, go to a third party rather than having to appeal to the board itself. And look for adoption.
Your second?
Second.
Okay. Questions?
Call for the vote. Good.
Sandy Gupta from Workforce Development would like to make a few comments.
I guess just to summarize some of the discussion yesterday. First of all, I think from the governor's plan perspective, we don't feel this amendment is necessary because we feel there is adequate consideration already built into the process to allow for employee grievances and appeals to be addressed up through to the top authority or management of the system. The second point I think we'd like to make is that, again, we shaped this process to be comparable to processes that are in place for other universities in the state. And if this kind of option is provided for the KCTC system, I think there could be raised both legal and constitutional questions about that same privilege being provided to employees in other universities across the state. And so we caution that we believe this sets a significant precedent for dealing with employee appeals beyond anything that has been brought before this assembly before. And with that, we'll take questions if you'd like.
Questions? Comments? Anybody?
I'd like to go ahead, Joe.
Well, again, Mr. Chairman, what we're doing is putting a lot of detail in a bill that has a general vision, and I don't think we need to do that. I think we're making a big mistake when we stick this sort of thing. That sort of thing needs to be worked out through the process. This bill has a very broad perspective, and I think when you start allowing individual groups to put in little details, you're going to wind up screwing up the whole process. So I think it's a mistake. I would urge you not to vote for it.
Yes.
If I could respond to Representative Clark again, just some of the structure that's been designed. Under this process, like similar to other universities, you have empowered the top Board of Regents with the responsibility for overseeing its employees and making decisions about employment as well as any kind of grievance or appeal action that might take place. With this proposal, what you're doing is saying we're going to take that authority away from that board and give it to a separate party to make determinations regarding their employees. Now, that is an unprecedented action as it relates to not only state government agencies, but certainly the university system.
Okay, yeah. Really?
Can the board at this time, as it is in the bill now, either dispute the grievance or have a designate of the board dispute the grievance? They could even refer it over to the personnel cabinet, or can you explain that?
Again, to caution, moving the workforce development employees, we are taking them out of state government and putting them in a system comparable to other employees in universities, in the state. However, the bill does allow that board to determine a designee or some representative, if it chooses not to do it on its own, to hear grievances or appeals. That language is in the law. What this amendment would do is not give them the option of making that decision and clearly put it over there without their approval or their decision-making part of it.
May I speak? Let me explain to the committee why we originally brought this amendment on this bill. In 1990, this General Assembly made the decision to move the vocational school system out of the Department of Education and put them in the Workforce Cabinet. When they did that, they also made the decision to take away all of those employees' third-party appeal right at that time, which was the Personnel Board appeal right. They set up a system similar to what we're talking about here, where all employee personnel appeals go back to the board that runs the system. Since 1990, we have had a nightmare of problems and employees coming to us saying that they had no faith in the system. They were losing appeal after appeal. They did not feel they got a fair hearing. We have asked time and time again to have those folks be able to appeal back to the Personnel Board. In the 7 years since the system has been in, we have not been able to effectively get a third party for those appeals. What we are now telling people in the Workforce Cabinet that are under that board, that if you have a personnel problem, do not go to the internal board because it's a waste of your time. Go ahead and file legal action. That's a situation that we do not want to run in the new system. We do not want to end up in court over every personnel dispute. We want to have a system that avoids legal action, that avoids litigation, where we can settle employee personnel disputes in a way that the employees feel comfortable that if they lose, they're not losing because the same people who made those rules had an opportunity to decide whether those rules were fair or not.
If I could respond to that. Thank you. What he's referring to is the employer is making the decision regarding his or her employees. And the question is, do you want to remove the employer from that chain and allow a separate, non-connected body to make a decision regarding the employees of another organization? Secondly, I would say the history in the Workforce Development Cabinet tech system regarding the employees is completely overstated. We have our general counsel here that I'd like to maybe ask if she could come to the table, Beverly Haverstock, who can share with you how many court cases there have been and how comparable in terms of low numbers that is to any other agency in state government. The other thing I would add to that, then I'll let Beverly speak, our State Board for Adult and Technical Education, I think what Mr. Wells is referring to, the employee appeals or grievances that have been presented to them, we have followed due process through the law, which, Beverly can explain in more detail. And when that has been presented to the board, they have come down on the side of the hearing officers we have used and agreed with the decisions that they have made regarding those employee actions. And if the employee is still unhappy with that, I don't dispute that there may be those situations. The question was appropriate due process and appropriate review provided, and our state board has come down in favor of that. Beverly, why don't you get the process?
Mr. Chairman, thank you. It is an aberration almost in state government for an independent, and I'm not sure how loosely we can use that word, personnel board, because you make the laws for the personnel board and it's regulated as well as the personnel department. So I'm not sure how independent and third party that is. But that is very different from most administrative law procedures. And administrative law is recognized by the United States Supreme Court as giving employees an opportunity and due process to come before their employers or their boards and be heard and be represented by counsel. And this has happened in the State Board for Adult and Technical Education. That board has not heard one case by an employee. A third-party, impartial hearing officer, by regulation, is employed in every single appeal. We have contracted with attorneys outside the state government to hear our cases, and we have also used and are now totally using assistant attorney generals, as this legislature has mandated under KRS Chapter 13A. So we have in place with our State Board for Adult and Technical Education, an impartial hearing officer who hears the cases and makes the recommendation to our State Board. And our State Board has almost exclusively followed the recommendation of the hearing officer. If the employee is still unhappy with that, there is a complete record made at the administrative level for the court to review. And that's a very efficient system. In the governor's bill, as I think Representative Marzian pointed out, the governor has provided in this bill that the KCTC board may designate someone outside that board as an impartial hearing officer to hear those appeals by employees. The governor has also provided in this bill more protection than the employees who will be transferred have now. And that is, the governor's bill provides an appeal before this board for all grievances. Neither in 18A nor in 151B personnel systems now does an employee have a right to appeal the fourth level of a grievance to any board. So our employees who are being transferred over have more protection in that respect than they do now, and they also have provided for them an independent third-party review.
Can I just add to that? Thank you. We want the committee to understand that we care about employees, and we want to make sure we put in place an appropriate process that keeps in mind consideration of their interest, and we have done that. I was going to ask Beverly if she'd explain to you the appeal process for employees so you understand how many levels of review are available before it reaches the Board of Regents, and then even there, you know, the option they have in court. This is a very extensive process that this amendment would add a whole separate level, even outside the organization.
Representative Trish.
I did have a question. Yeah, in looking at this, when we voted on this the other day, my impression of this was that since we have two groups of people we're bringing together, at least under the governor's bill, we have the community college folks who do not have the right to independent third-party appeal, as I understand it, and we have the workforce cabinet folks under the technical schools that, at least my impression was at that time, did have the right to independent third-party appeal.
Some of them do.
And that, well, let me finish with my question. And that is the premise on which I voted on this bill, or on this amendment, excuse me. And I guess the question I would have for the sponsor of the amendment or any of our panelists out here is whether we are breaking new ground specifically for those, for any employees that currently have a right that this bill would take away. In other words, I would rather grant new rights to a group of employees rather than take it away from some that are already protected. In other words, somebody has that protection already. I don't want to see them come into a system where they lose that. But if we're breaking new ground, and if we're going to give this to everybody, and they don't really have something comparable like this before, I think that's something we ought to take up in the 98th session and debate that issue at that point, or maybe on the floor at some point. But I would like a little clarification on this amendment as it is written, whether it protects the, not like in very plain language and some very short answers, whether it protects people that currently have this right, whether protecting that, or whether we are granting something new to those folks.
The workforce cabinet right now, as it's structured in the vocational school system, is split between the staff of the schools working under the 18A system and the faculty of the system working under the 151B system. The staff of the system currently have the right to a third-party independent appeal system under the State Personnel Board. They would lose those Personnel Board appeal rights under the governor's bill. They would have no third-party appeal right other than to go back to the KCTCS board. They will lose those rights.
If I could respond, just so you understand the employees we're talking about. We are talking about the 18A employees who in our system are primarily our administrative support staff. These are the employees who are still under 18A and would be able to appeal a grievance to the Personnel Board. Our faculty instructors and the larger group of employees, talking in the neighborhood of 1,300, are not under that. They are under 151B, and their employee appeals goes to our State Board for Adult and Technical Education. So you're talking about a small group of employees who are still under 18A, and they are the administrative support employees who had that privilege for being an employee in state government. Under the governor's proposal, we are converting and transferring to a comparable post-secondary institution model. So what you're basically talking about are 300 plus employees who are the administrative support staff that are being presented as the bulk of employees who may lose a right.
So we're talking about 300 employees that would, quote, lose something under this?
They would not have access to the personnel board because they would no longer be under the statutes 18A that give them the right to appeal that to a personnel board. By virtue of not being a state employee anymore, they would not have that right. But they would appeal their process to the board like all the other employees do now.
Okay. So it sounds like the split is about 300 administrative staff, about 1,300 faculty and others that are not covered under that. And I assume they're covered under something similar to what the universities are. Is there a rough analogy?
That's a rough analogy. I don't know if Beverly feels the need to clarify that, but...
Well, our community college system is again different.
I'm just talking about technical schools.
Okay, then it's correct. It was just technical.
Okay. Of course, the community colleges are under a university-type system anyway, so we're only talking about the technical schools. We're talking about 1,600 people affected, 300 of whom might lose something, 1,300 of which would gain something. How many people do we have in the community college system that would be affected by this?
Forgive me, but it's the other way around.
I'm sorry.
1,300 would have it the same. 300 would lose their right to appeal to the personnel board because they'd no longer be state employees.
Okay.
But they'd have a right to appeal to the board. It's the other way.
Okay, I meant it. I just didn't say it.
Let me just add, again, the governor's bill also grants an extra appeal, and that is of the grievance that none of the employees coming from state government have at the present time.
Okay. And question, do you know how many are in the community college system that would be affected? Any idea?
Forgive me. I don't know if I can speak to that, if anyone here can.
Not that big a deal. We don't need to go find out.
Sorry.
All right.
Yeah.
Any questions? Any more questions?
I want to make... Okay, he's got a question. Let him go ahead.
No, I just have a comment. My personal belief is, given that we're trying to create a new animal, I think the KCTCS people ought to have the right to design their own system as they see best. And if at some point we deem legislative intervention necessary because of abuses or something, I think the officers should have the right to do something better than we envision for them. And let them have a shot at it first before we come in from on high. So I would speak against the amendment.
Representative Graham?
Yes. I want to put for you some real-life situations. We've spoken of 151B. I know something about 151B. I worked in the Department of Education in 1990 when we separated the Department of Education and formed the Workforce Development Cabinet in a new personnel system. I stayed with the Department of Education by choice. Maybe I couldn't have gone to the Workforce Development Academy anyway, but maybe they wouldn't have taken me. But nevertheless, I was with the Department of Education and the people under 18A, which has an appeal process to the Personnel Board. A person, I don't particularly want to call a name, but a person that went with the Workforce Development Cabinet, an individual, if I were to talk about the program that she helped to develop, it's a nationally recognized program. She was nationally recognized as an educational leader, but went with the Workforce Development Cabinet under 151B. Shortly thereafter, this individual was removed from supervising that particular program, which, by the way, this General Assembly passed and receives a national recognition for that program. She was removed from working with that program. She was lost. Now, this had been approved by this so-called board. It's impartial. I say to you, boards cannot be impartial in dealing with things of this nature. I attended a hearing that an education committee had regarding this particular individual and this particular program, because they were questioning this person about her abilities and were investigating her. Rumors I heard that she was running rampant. She had never had supervision. I was there because I was her supervisor. I knew she had supervision. She was simply an excellent worker, the kind of public employee that I think anyone in this room, if you knew the situation, would say, applaud her for what she has done and accomplished. But she continued to be investigated, put down, and I saw this individual almost broken. She eventually retired. I know of a second instance, a more recent one, that was very similar in nature. If I recall that person's name, people here on this panel would recognize that name. But she didn't, she was within the system. And her appeals process were going to go to the board. She felt useless to do that. So she took retirement. I say to you, I don't really see where the great problem with this is. Put it in there. It's not that many. Some have said, I've heard it said here, well, others are going to do it. Well, is that bad? I don't know. But I don't like to see you causing other people to suffer, and they're going to suffer. I dare say more wrong by these two individuals left state government. When I personally know quality in running good programs, but we're forced out. Now, it would be well and good if all the people at the hierarchy making these decisions, you could always say, they're the enlightened despot. They're going to always be doing the good things for people. But we don't always have that. We haven't had that. And I dare say we will continue to not have it on a continuous basis. I simply say, put this in there. I speak very fervently for that. I hope you pass it. I think we'll be better off if we do than if we don't. So.
Call the roll.
Representative Alexander?
Yes.
Representative Barrows?
Yes, ma'am.
Representative Clark?
No.
Representative Coleman? Representative Coulter? Yes. Representative Graham?
Yes.
Representative Kerr?
Yes.
Representative Lyle?
Yes.
Representative Marzian? Pass. Representative Minyard?
Pass.
Representative Moberly?
Pass.
Representative Murgatroyd?
Pass.
Representative Rash?
No.
Representative Reiner?
Yes.
Representative Tyler? Representative Sims?
No.
I'm sorry?
No.
Representative Stein?
Yes.
Representative Pritt?
Aye.
Representative Walton?
Yes.
Representative Kurz?
No. 11-5, the amendment passes.
Mr. Chairman, I move that the staff be directed to put these amendments in a committee substitute, which I guess we would designate as committee substitute number 2, and that it be reported favorably.
All in favor say aye.
Aye.
Opposed, no. Motion carries.
Motion made and seconded for the adoption of House Floor Amendment number 8. Is there discussion?
Chair recognizes the gentleman from Franklin 57 for discussion on the motion.
Mr. Speaker and ladies and gentlemen of the House, I'm the person that had this put in the committee. I want to emphasize to you that it does nothing to change the governor's bill. I talked with the governor. The governor told me he had absolutely no opposition to the bill. Now, I want to tell you why I sponsored it. First of all, I believe in fairness and dignity for all employees. My good friend from Mercer, he also represents one precinct from my county, Franklin County. Now, I realized when I was elected to this position to represent most of Franklin County, my good friend Joe Barrows also has precincts in this county. But I understood that I had the responsibility to speak out for state government employees because within Franklin County, I understand there's something like 6,000 state government employees. But also, I want to remind you that you also represent state government employees. State government employees work in every county. Now, I think, in my personal opinion, I have greater insight to this issue than anyone in this chamber. I worked for 16 years, a little more, in state government. I worked in two departments, transportation and education. I worked as a non-merit employee, and I worked for the most part in the ranks as a merit employee. I enjoyed working in state government. I considered it an honor. There are many quality people in state government. I found them to be as top quality as the time I taught in public schools or small college in Louisville or the times I served in military service. They're quality people. Now, my friend said it would be approximately 2,300 people. I called Workforce Development Cabinet. They said to be something like 1,000 could be transferred from Workforce Development Cabinet to this new board. But regardless, if it's 1,000, 5,000, 20,000, what have you, the idea of any employee, when they're having any type of a grievance procedure, to have an opportunity to finally, ultimately, have someone who's supposed to be non-partial to hear it. That's always asking. I appeal to you not to read anything more into that. Now, I feel because we have new members in this chamber that I should talk just a little bit about 18A and 151B that was referred to. 18A is part of the personnel policies. We have determined personnel policy for state government employees. And it's in 18A, it says that if an employee has a grievance, it can ultimately be resolved by going to the state personnel board, which is made up of 5 appointees by the governor and 2 state government employees. But that's the third party I'm talking about, supposedly an impartial body to hear it. Now, 151B, my good friend said this new board is going to be able to establish their own personnel policies. Now, I was in state government in 1990. I was in the Department of Education, serving as office head of adult and community education when legislation was passed to form Workforce Development Cabinet. And it said the Workforce Development Cabinet would establish their own personnel policies. Now, as a part of their establishing their own personnel policies, they put in what is called 151B. Now, in 151B, if a person working in the Workforce Development Cabinet has a grievance, they can appeal their grievance or however you want to determine this about your legal language. But ultimately, the last place they go to is going to be to the board, the Vocational Technical Education Board, who in essence is over everything about them already, and it's like a glass ceiling. You go up and it comes right back at you. Now, if all people who were appointed to boards and leadership positions had good leadership qualities and practiced what is considered to be effective leadership principles, and if all employees were hired on merit and qualifications, I dare say we'd have hardly ever any personnel grievance appeal. But my experiences have taught me that that doesn't exist yet. Now, in the Education Committee last week, when the attorneys for the Workforce Development Cabinet and another spokesperson from the Cabinet was talking about this, I could not help but reflect back to about 1991, after these policies were put in place, of a person that I had worked closely with who had gone to the Workforce Development Cabinet. I chose to stay in the Department of Education, but at one time I had been the supervisor of this person. This lady directed a program that the General Assembly received a national award for back in the mid-'80s for initiating good educational legislation. She's a quality individual. I think anyone who'd been around her would acknowledge that. Very knowledgeable, hardworking, and really was trying hard to make this program become an effective program. She was concerned about having quality control, the research on it to see if it's really going to be effective. The things that sometimes people in education are criticized for not doing. But she was doing it. But all this change, when it went over, the people in the Workforce Development Cabinet, for some reason, pulled the plug on her. They placed her off into some other task that did not mean much to her, this qualified person. And the thing that really got to me was there was an education committee meeting when she was there, and I heard the secretary of the Workforce Development Cabinet and the attorneys for the Workforce Development Cabinet talk about how ineffective she was and that she's going to be investigating. I attended that meeting just because I heard it was happening. I was still a member, employee of the Department of Education, probably had no right to be there, but I can tell you, I confess to you today, I wish I had had an opportunity at that time to enter into that discussion, because the lady was wronged. She ultimately just got out of state government because of her treatment. Now, I say to you that that is not an isolated case. All we're asking in what is already in the bill is to let every employee, I don't care if it's all of them, I don't think it's too many to have 2,000, 5,000, 10,000, whatever the case may be. All human beings deserve it. Now, you are a public employee. Every member here is a public employee. You receive a check from state government. I dare say, if something you were operating and you wanted to appeal some process, I guarantee you, you'd like to go to an impartial part. That's no more what we're asking. It's to me, it's really a very simple issue. Now, in my view of a legislator is one who will champion fairness and dignity. A state employee is worthy of fairness and dignity. That's all we're saying. Now, some have read more into this than what it is. This has nothing to do. I don't know whether we'll come back to this thing in 1998 and 2000, maybe so. I'm just simply talking on this one issue. This one issue is worthy of standing on its own feet, on its own merit. We're simply saying, let people who work in state government have a third-party appeals process that's supposed to be impartial. That is all. And I urge you to defeat this amendment. Thank you.
Gentleman from Mercer 55. Mr. Speaker, the gentleman from Franklin is a good friend of mine, and I know he speaks passionately on this issue. But we all have state employees in our districts. I have many state employees in my districts. He was correct when I stated the third-party appeal process is a separate issue. We have put 950 Votex Center employees that were currently given their grievance and appeal processes inside the system, and 1,000 faculty members from the community colleges who are currently doing their grievances inside the system, and we have set them apart in special legislation. If you will, for a minute, go back to page 22 of the bill. These employees are transferred with all rights under the merit system or all rights for the, all rights of tenure and all rights of the merit system. The appeals process, again, is something that we set aside for about 2,000 employees. If we're talking about fairness, if we're talking about treating employees correctly, with dignity, and we all agree with that, then I think that the issue needs to be for all 22,000 employees of the higher education system and not just 2,000. That's the issue. I understand there are certain instances in state government when things don't go right, but we have the merit system, we have the tenure system, and the KCTC board that we've empowered to promulgate new personnel rules and regulations. We should not usurp that power immediately and not trust them to do what we think is right. Again, in closing, we have protected the rights for third-party appeal for 2,000 people while leaving 19,000 out in the cold and not with the same protections. That is the issue. Thank you, Mr. Speaker. Chair recognizes the gentleman from Oldham 59 for discussion on this matter.
Thank you, Mr. Speaker. With regard to this particular amendment, if you have read the language on page 25 of the bill, on line 22, there are 3 words that start out as independent third party. Now, if you look in the definition section of the bill, nowhere is there listed anything that describes who the independent third party is. What we have here is, again, good intention. Matter of fact, I personally like the appeal process. I like the idea of an independent third party. But I think what we need to do is define who that third party is going to be. There's 2 ways to do that. First of all, we could have done it through a floor amendment here to straighten out the language. That didn't happen. The second thing is we can hope that the Senate straightens this out. Now, what I would personally like to see is that this definition draws from the existing list of arbitrators that arbitrate labor management disputes. I do not trust the Senate to fix this amendment. Therefore, I think it's very dangerous that we leave it as is. I would suggest that we pull this language out of the bill. If it is really in the best interest of the employees, I would even go with the gentleman from Franklin in support of his concept and ask that the Senate draw up an amendment that would specifically define the independent third-party arbitrator and define as to who it will be, because I think on this floor, the major concern is who is that arbitrator going to be? We think it's going to lead to some other things that will be dangerous for state government. It's very difficult to get up and argue against my seatmate. He is impassioned about taking care of employees in state government, and I think he should be commended for that. He has the same energy and emotion to his constituency as the gentleman from Letcher does. He is to be commended. And he's absolutely right in this issue. However, I think the language is definitely dangerous, and I think it needs to be fixed in the Senate. I would urge you to strike this language from the bill. Thank you.
Gentleman from Johnson 97, did you wish to discuss this matter? Gentleman from Johnson 97.
Thank you, Mr. Speaker. During the session in 1996, I had a bill that affected these people with an appeal process where they had to go back to the people that had disciplined them at first. We wanted to appeal to where they could go before the Personnel Board, and we felt have a fair hearing rather than the people that had done the disciplining at first. That bill passed this body by a large majority. It went to the Senate, and we had one individual that refused to call it before the committee because of, I'll not go on and say why, but it was because of some individual differences. So I would urge you to defeat this amendment, and if it needs changing, go ahead and change it in the Senate. I have no problem with that as far as getting who it may be, but I think we should defeat this amendment and give these people their fair right. Thank you, Mr. Speaker.
Chair recognizes the gentleman from Mercer 55. Mr. Speaker, again, to get back on the issue of what we're discussing, the board shall adopt on page 22, grievances shall be to the Board of Regents or the board's designee for the techs and for the community college faculties. We already have that in language. We have empowered the KCTC board to adopt personnel rules and regulations. And I don't feel like at this time we need to pull out 2,000 employees in special legislation when we have a remainder of 19,000 that we have not addressed. So again, I would urge you to support this amendment. Chair recognizes the gentleman from Franklin.
Thank you, Mr. Speaker. And the gentleman from Mercer was reading, I think he said page 22, that the employees bring with them the rights that they currently have. And that's part of the issue. The 300 or so employees under 18A already can appeal to a personnel board. There's no problem. So they bring that with them. Those under 151B do not have such an opportunity. So they bring that with them. So all this is saying is simply allow all the employees to go to a third party. Now, I appreciate the gentleman from Oldham. I think his comments were very appropriate. I have no problem with what you said. In fact, the Labor Department has said that they could be the third party in this and let it be known, and said without having to employ any additional people, the intent is simply very simple. Allow a third party, independent party. There are no hidden agendas in this. So I just appeal to you to defeat this amendment.
Gentleman from Marshall 6, you're recognized for discussion, sir.
Speaker, ladies and gentlemen of the House, I'll be very brief. I know the hour is running just a little bit late, but in speaking against the amendment, I'd first of all just like to congratulate the gentleman from Franklin. Probably no one has any more insight or any more compassion for the state employees than this gentleman does. I think that we all owe him a debt of gratitude for the manner in which that he has tried to help these employees and to help to assure them that if somewhere down the road something happens to them that might not be considered appropriate, that they do have some relief valve to go to. I, like someone else who spoke on the issue before, recognize and realize that there is a dispute resolutions group over in the Labor Cabinet, and I feel sure it would be no problem for them to set up a procedure that would help here to no end. with the time running short like it is, I think we need to leave the bill intact as it is and not attack it as it attempted to be done here, and let the gentleman from Franklin work with the others who have some ideas on it. And I feel like if they can meet with some cooperation in the Senate, that will bring about an appropriate resolution. So let's don't, miss a golden opportunity to really provide some protection here.
Is there any further discussion? Gentleman from Mercer, 55. Mr. Speaker, I would concur that the gentleman from Franklin is very passionate and concerned. I'm very compassionate and concerned. But we're talking about 23,000 faculty, employees of the community college, higher education system. We're not talking about 2,000. So if we're going to be fair, let's be fair to them all. I urge you to pass the amendment.
Question now is on the passage of floor amendment number 8. Two members having called for a roll call. All in favor vote aye. Those opposed nay, and the roll call machine's open for your vote. Have all members voted? Clerk will take the roll. Roll call machine showing 26 members voting aye, 69 members voting nay. The motion's lost.